Hello, hello, thank you for joining me. Okay, we are going to get started here. So, estate questions and answers. My goal is to come on here every Wednesday at 6 p.m. to get your questions answered about estate planning. So, this can be things relating to, what are wills, what are trusts, what is probate court. If you have somebody that passes away, maybe answering questions about what needs to be done or what are some steps that you can take. I'm here as a resource for you. I know that estate planning can be very intimidating. And one of the things that I'm hoping to accomplish by doing this is to really just try and get your questions answered to try and make this process not so intimidating for you. Um, just a few things. If you have any questions, put them in the section. That will allow answer the questions for you. Some questions that people have emailed me, so I will be going. So if you've joined, comment that you're here, that I know you're here, and if not, feel free to send me a message if you don't want to post your comment. So for those of you who don't know me, I'm an estate planning attorney. Practice where we focus on educating families with minor children. While it isn't possible that we get that question a lot. So our clients range from 18 to I think our oldest client right now is 96. So we help clients with their plan as planning, what we call planning. So if you have a family, one that's passed away, just helping administer, whether it's through state or trust administration, to figure out what needs to be done. So we do an array of all of that type of work for clients. Okay, so let's get to our first question. First question we have is, what is a will? I think a will is probably one of the most common estate planning tools that most people know about, and it's really, especially for, you hear people time, it's the reading of the will when somebody passes away. So break down some of these barriers of what a will actually is. This as a disclaimer, I'm an attorney licensed in California. So information that I'm providing is related to California only. If you do have questions in a different state, please reach out to an attorney in that state to make sure that the information is true for your state, because everyone's different. So what is a will? So a will is basically just a legal document. You state upon your passing how you want your stuff distributed. It allows, if you want distributed, family heirlooms, you can put that in your will. If you distribute your estate, if you have children, if you want 50-50 to go to your two children, or if you don't have kids and you want your estate to go to a charity, this is in a will. You're just joining us. If you have any questions, please make sure to put the comments and I will try to get to those. So that's what a will does, you to state how you want your estate distributed if something were to happen to you. Only goes into effect upon your passing, and it's filed with the probate court. Some of the big misconceptions I see with people with wills is, hi, thanks for joining, is that a will is not private, right? A will says how you want it distributed, which means once it's filed with the probate court, it becomes public. So anybody can go down to the courthouse and find out what you own, who you owe money to, and who's getting your stuff, because that will is public. You see it all the time when a celebrity passed away and they're able to go figure out who's getting the stuff according to what's listed in that person's will. So, that's one of the biggest things I hear with people thinking that a will does stuff doesn't keep things private. It just guarantees probate court. Other things that you can do is you can say who you would want your guardians to be if you have minor. So nominating guardians of minor children that we do in the will. personally, we actually do a separate document in addition to the will, just to make it very clear. That way, if there's any changes in the future, it's easy to update the document, because that is probably the biggest that we see relationship is changing guardians for children. So that's what a will is. Things I will say about having a will is a will is going to guarantee, and that probate court proceeding is very expensive in California, and it doesn't prevent process. And a lot of people think it will prevent going through probate. It doesn't. What will does is say how you have distributed. It's telling the court this is stuff distributed, so it has to go through probate, and probate court in California is very long. The other thing with probate, or with having or not having a will, because I have seen an increase in people that have passed recently for helping, and they don't have any documents, they don't have any will or anything, so we don't actually, so they haven't said how they want their stuff distributed. So when somebody California without having a will or that type of document, then their estate is distributed to what we call intestate law. And it's basically how the state of California says how your stuff is distributed to the people in your family, or your heirs, as we would call it, if you don't have that will. And without having a will, it may not be distributed according to what your wishes actually are. And I'm seeing this a lot where we have older clients that have passed away. They do not have any planning documents, and maybe there were hiccups in the relationship over the years where where the children that they have, maybe they aren't in contact with one of those children anymore. Maybe there was some type of, well, if you don't specifically see documents that want this child to estate, then heir and heir, they would receive an equal portion of your estate according to intestate law. And I've seen that want it to happen, but it is happening because they don't. So it's really important that wishes are and to do these planning documents. Let's see. Let's get to the next question. So joining us and you have any questions about estate planning, wills, trusts, probate court, if somebody passes away, if they own property as joint tenants, or community, or husband and wife as community property, please feel free to put those in the comment section and I will try to get to those. So if you're just joining us again, put any questions that you have there. You can also send them to me privately. Okay, so let's get to our next question. Okay, next question. So what is probate court? So great question, especially because I just went over what a will was. So probate court in California is the process that when somebody passes away, all of the stuff that they have in their estate, meaning all of the stuff in their name, bank accounts, if they own property, have life insurance policies, retirement accounts, all of the stuff that they have in their has to go through this process where it's redistributed to heirs. Probate court is basically just somebody's passed away. It's notifying heirs that, do you have any claim on any of this estate? Do you have bills that are outstanding, things that need to get paid? It's identifying and notifying who the heirs are to know that they could be receiving something from this estate. And then it's distributing it to the heirs, or if there's a will, according to what the terms of the will are. So probate court in California is a long process. In some states, it's a very streamlined process. It's not very long, but in California, it is a very long process. It's also very expensive. The fees to go through probate court are set by statute, by statutory fees. And so it's actually identified that you can know, depending on the value of the estate, how much the fees are going to be for both attorneys as well as the personal representative, the person who is administering it through the process. The process in California, at least in the areas that typically serve the most, which would be Ventura County and LA County, it's very long. It can take anywhere from 1 to 2 years. With the recent closures that we've had, we're looking at adding another 3 months to 6 months onto that already long process, because the courts are so behind. It's going to be interesting when the courts open how they are going to start kind of processing these probate matters. So another thing I mentioned before is probate is completely public. So anybody can go to the courthouse, find out what you own, who you owe money to, and what's going on with your estate. So that is probate. Generally, when we are working with clients in the planning side, probate court is something that we try to avoid, and we can do that by doing planning documents, which is great, because we have the ability to avoid probate, knowing that, you know, we can plan ahead. The biggest thing with planning is you want to make sure that when you have the ability to plan, you're healthy. Things are, you know, there isn't necessarily something that you're planning for. It's just this planning state. It makes it the easiest to plan and probably the least expensive, because you're not doing this crisis planning where it could be more expensive. And generally is, especially if probate court or the courts need to get involved. Okay, so if you're just joining us, please make sure to share your comments that you have, or I'm sorry, any questions that you have that you want me to answer from an estate planning perspective, and I will try and get that answered for you. So let's go ahead and get to next question. Okay, do I need to nominate guardians for my minor children? So this is a really great question. If you have minor children, so any kids that you have that are under the age of 18, these are going to be your minor children. Without having a guardian nomination, if something happened to you and the other parent of your children, the court would have no idea who you would want to be the guardians of your kids. That's why it is so important to make sure that if you have minor children, you are doing some type of guardian nomination, whether it be in a will or in a separate document that says, if you have minor children and something happened, these are who you would want to be the guardians for your children. Because without having this documentation, this legal documentation that says who you would want to be guardians, if something happened, the court would have no idea who you would want. And that's why it's so important to get these documents in place. And if you don't have them and you have questions, please let us know. I am happy to answer those questions for you. The reason why it's so important to have these documents is, and because without them, the court would have no idea who you would want. And I understand that a lot of times people don't do planning because they can't decide. And that is one of the worst things that you can prevent yourself from completing it, for that being the reason. Because you having something is better than having nothing at all. Because without it, the court has no idea. But at least if you're able to put something in writing to start, you can always change your mind and update it. Like I said before, this is probably the #1 thing that we get updated with our clients, is that, you know, things change over time. They're going to change their guardian nominations. You know, people are going to go in and out of your life. People are going to get sick. You're going to get new people in your life. And so this is something that you're going to update throughout your life while you have minor children. So that's why it's so important. But at least doing it now with the people that you've identified that you would want to be guardians, at least it's something in writing. And I will say also, when you're doing guardian nominations, it's important to make sure that you not only have a primary guardian, but also backup guardians, because you never know what season of life somebody's going to be in, or maybe they were in a car accident with you. You know, that's why it's so important to make sure that while you're also identifying guardians, you have a primary guardian that you are identifying, as well as backup guardians. If you have any other questions on that, please let me know. One thing that I will share with you that we have as a resource is our planning guide for parents. And this is a great document that allows you to know, you know, things to ask, things to keep in mind, to know who to nominate for guardians for your minor children, as well as lots of other planning questions that I find that clients have. If you want this, please send, either put your your email address, or say, you know, I want the guide in the comments so that I can go through, and I will send you the link to be able to go in and request that guide. Okay, so if you're just joining us, make sure to post your questions in the comments so I can get to those. We do have time for a few more questions here, so if you have any questions, please make sure to put those in the comments. Let's see. If you have any questions that you don't feel comfortable asking, you can always email us, info@hermanslaw.com. If you want to schedule an appointment, you can go to our website, hermanslaw.com. In the upper right-hand corner, there is a book an appointment now button, and you can choose an appointment online that works for your schedule. Okay, let's go to the next question. Okay, what is a trust? This is a really great question because I feel like a lot of people have this kind of misconception about what trusts are. I will start by saying that trusts are for the wealthy. Trust that wants to put a plan in place that their family is protected. Keep things private. It makes sure that your wishes are in writing, that there are people that you've identified that are what we call fiduciaries or trustees that have this legal obligation to make sure that your wishes are carried out. There are ramifications that if they are not carrying out, the courts can get involved. So that's why it's so important to make sure that you have these legal documents in place. So just to give you an idea, like this is our estate planning binder that we do. The trust is a large portion of this that we do for our clients. So what is basically just a legal, you as the grantor, which is the person who creates the specific instructions in writing to the trustee, agrees to hold legal title to all of the assets, and they do this for the benefit. So while you are with the living trust, you are all three of those roles. You are the grantor, you are the trustee, meaning you are in charge of all of the assets in your trust, and you are also the beneficiary. So while you are alive with a revocable living trust, you can do anything you want with all of the assets in your trust. It's only if something were to happen to you that you have your, what we call your backup trustees, your successor trustees, that would then follow the instructions in your trust according to your wishes. So what a trust does is it avoids probate court, right? If you have a fully funded trust, meaning you have all of your assets, so if you own your home, your trust is in the bank account, your bank account is in your trust name. Maybe you have life insurance and minor kids. So rather than having your minor kids listed as backup beneficiaries on your life insurance policy, you have your trust listed as backup beneficiary on your life insurance policy. So if something happened to you and your spouse, that money could then go into your trust to be distributed according to your wishes for your kids. So when we do trust for families that have minor children, is rather than receiving everything outright would through probate without a trust in place, then maybe in their trust they would look at is that you said they were at 25, half at 30, and the remainder at 35. So it's really spreading out any of that money that they were over the course of their life rather than everything when they turn 18. And so by having a trust, you can put those specific parameters in place to make sure that that is carried out the way that you would want. So a trust really, I mean, there's a lot of benefits to it. Again, it keeps things private. It avoids that long probate process. It keeps the cost substantially down according from what those statutory fees are for probate court. Okay, so that is what a trust is. That is probably our biggest planning tool that we have for families, whether they have minor children or no children at all. But you know, if they own a home, especially in the state of California, having a trust is generally going to be the best option. Ensure that things is saving the hassle of probate court. And I'm getting a lot of new clients recently that have family members that have passed away. They don't have any planning documents at all. They don't have a will. They don't have a trust. They own their home in their own name, which means it's going to have to go through probate. It's that 1 to 2 year process to get that distributed to their beneficiaries. And it's unfortunate when I see clients that come in like that because they don't know that there's actually planning tools that they can use to avoid that. And that's really what I try and do, is educate families on ways that they can put these plans in place to avoid that probate process. Okay, again, if you have any questions, please make sure to post those in the comments. I have time for maybe 1 or 2 more questions. So if you have any questions all, please make sure to get those in there. If you have any questions and you don't feel comfortable posting them here, you can always email us, info@hermanslaw.com. Or you can also call our office or text us at 805-518-9633, and we can kind of get you started in whatever that process is that you need help with. Okay, let's go ahead and get to our next question. So, my grandma just passed away and she owned her home. What do we need to do? So there's a couple different things that we look at in this type of situation. Is if she owned the home in her own name, does she have any type of planning documents? Probably the best scenario would be that if she owned that home, that she had a trust. And hopefully she did, where she owned the home in the name of her trust rather than in her name personally. Because that goes back to some of the things that I talked about before, where if you own the home in your own name, it would then have to go through the probate process. But if it's owned in the name of the trust, then it's just administering the trust. So then it's going through and working with an attorney. That's what we do with clients. You know, what did the trust say? Who is the successor trustee, the person who is then administering the trust, and just following the instructions of the trust of how to the assets of the trust according to the to what you need. If your grandma and maybe she had a will. So then it would be looking at what the will said of how she would want her assets distributed. But with a will, depending on what the language is, it would likely have to go through probate court to be administered, especially if she owned a home. And then it's following what her requests were in the will. But you would still have to go through that probate process to administer the will. And it, again, depending on where she lived or where the property was held, following whatever that county's probate proceedings are. In Ventura and LA County, again, it's, you know, looking at 1 to 2 years right now, especially with all of the court closures. It's a very long process. There's a lot of fees that are associated with it. So statutory fees, and just to kind of give you an example of what those fees would be. So when you look at statutory fees, you look at what the value of the estate is. And so if, let's just say there was a home that was owned, and we'll keep it on the low side, just especially with California and house prices. Let's say the house is worth $500,000, and we'll just use that as kind of the basis for assets. The way that probate fees work, the statutory fees are, it's kind of this sliding scale. So you look at 4% for the first 100,000 for fees. So that's 4,000. You're looking at 3% for the next 100,000, which would be $3,000, and then 2% for the next amount of statutory fees up to $800,000. And so if you're looking at a $500,000 house, and I'm doing this as math, a lawyer, and I don't do math very well, so I am using my calculator. So if you're looking at about 500,000, so 4,000 for the first 100,000 for the next 100,000, and then for that additional 300,000, you're looking at about 2% of that. So 1,000. So that's 6,000 plus 3,000 plus 4,000. So for a $500,000 house, just attorney's fees is $13,000 that it would cost. That's just attorney's fees. If you have a personal representative or somebody that's administering it, they also get $13,000. So that's $26,000 that is being paid for the attorney's fees and the personal representative fees. That's not court costs or anything that has to go through. Everything that it takes, filing fees, anything that has to do with notifications, all of these other fees add up. So it's very expensive to have to go through probate court, especially if there is a home that is owned. It's a lot of money, and that's what we generally try and do, is by avoiding probate, by doing that planning beforehand. So, depending on what type of planning documents your grandmother had, it's hard to say, but I'm happy to talk with you about it. If you can provide some more information to me, you can set up an appointment by going to our website, clicking the appointment there in the corner, and setting that up for the trust administration or probate consult for us to be able to walk through what planning documents, if any, that she had, to kind of get an understanding of what kind of maybe is that path for you and your family to take. Okay. If you have any questions and I didn't get to it today, I apologize. Please make sure to email me, info@hermanslaw.com, and I will be happy to get to any of those questions that you have. You can always visit our website, hermanslaw.com. There's lots of information, as well as a lot of videos that talk about all kinds of stuff, from will, trust, guardianship, nominee, insurance if you're divorced. How do you do planning in that side? There's lots of informational videos on there to go check out. There's lots of information. If you want any of those guides that I told you about, please make sure to put your email address below, and I will post a link to that also in the comments. So thank you so much for joining me today. I will be Wednesday at 6 o'clock to answer any of your estate planning questions that you have. Thank you again for joining me, and have a wonderful night.